And welcome back to Law and Society with Andrew Stevenson, attorney at law, StevensonCriminalDefense.com. He's the four magic words. I want my lawyer. Just remember that. That's just the best. If we give that advice and one person follows it out there, we've done our jobs. Well, we'd like to do more, but that's a good start. I want my lawyer.
Yes.
All right. Now we're talking in this part. This is our show about DUI, OVI. See, I'm old-fashioned.
To me, they're all interchangeable. But yeah, drunk driving.
Drunk driving, driving under the influence, driving impaired. It's all in the OVI rules now. So, to blow or not to blow?
Yes.
That sounded bad, but it's true. That is the question.
Yeah, and that's a very common question we get. If you called most defense attorneys, the standard answer that most people will give is don't take the test.
Okay.
And the reason why is that most people fail. In my career, I've seen probably on average maybe 3% to 5% of people.
Even if you are stone cold sober, I'm going to ask you this. Distracted driving, drunk driving, we can get into whole, why distracted is worse. But
let me give you my answer.
Okay, go ahead.
Yeah. That's the general answer.
Okay.
And however, that's not exactly my answer. My answer comes in two parts. First of all, it says that take the test if you're going to pass. Okay? Now, that's self-serving and easy to come up with. Obviously, if you're going to pass this test, and you will know, if you have had 2 beers, you're going to pass.
Okay.
If you've had 2 glasses of wine, unless you weigh 82 pounds and it's been in 20 minutes, you're going to pass.
Okay.
The average beer puts your blood alcohol level at about 0.02, and every hour you will eliminate about 0.15 of that.
Okay.
So 4 beers in an hour puts you about 0.08. After 2 hours, you're going to be below. But the second part of it is that you shouldn't take the test or you should take the test if your situation dictates it. Now, let me go back a little bit. In order to be asked to take the test, to take a chemical test, either a breath test, a urine test, or a blood test, the officer must first place you under arrest. And to place you under arrest, they have to have probable cause to believe that you're actually under the influence or impaired.
All right.
That's where the standardized field sobriety tests come into play. That's where your driving comes into play. That's where the smell of alcohol comes into play. Your behavior with the officer, how you act, things along those lines. And so if they do place you under arrest, they've already concluded that in their opinion, you're impaired.
Yeah.
Now, they also do, in my opinion, they won't take a chance with somebody. The officers will not let someone who they think might be impaired continue to drive on down the road for liability reasons, and for the person's benefit too. So you're in this situation, and the officer has placed you under arrest, and they say to you, "Listen, I'm going to ask you to take a chemical test, a breath test, and here are the consequences if you don't. And if you don't, you're going to lose your license for a year." That's the thing that they tell you right out of the gate. And they say, "But if you pass the test, you won't lose your license." Now, keep in mind, they've already placed you under arrest, and they have already charged you with violating the second type of DUI, the under the influence type. They just want to shore up their case and be able to charge you also with the over the limit kind, which is
more severe. Yeah.
No, it's not. The penalties aren't any more severe, but the proof is different.
Yeah, okay.
It's the over the limit is an objective test,
whereas
it's the under the influence is subjective.
Right. It's their opinion.
It's their opinion on how you did on the field sobriety test. It's not what did the machine say.
Right.
And you can't challenge the machine. In general, you can't. In Ohio, you can't come in and say, "Listen, these breathalyzers aren't accurate." There's studies that have been done that show that they don't accurately measure your blood alcohol level. There is some discrepancy from person to person to person. You can't challenge the machine. You can challenge the individual test that you took. Was the machine working properly the night that you took it? But you can't challenge the test.
Still pretty tough road to hoe.
Yeah. So if you refuse, you are going to immediately have your license suspended by the officer, and this is a BMV suspension. Okay. This is not the judge. This is not the court system. This is the BMV that says, because when you got your license, believe it or not, you signed and agreed to provide a breath sample. It's called implied consent.
Okay.
It's one of the things that you agreed to do when you got a driver's license in the state of Ohio. It's implied consent. And so when you renege on your agreement with the BMV, they then say we have the right to suspend your license. Now, they suspend it for a year. This is the BMV. And there's a hard time suspensions that come with it. And so if it's your first offense or your first refusal, it's a 30-day hard suspension, which means no driving privileges of any kind, period, end of discussion. If it's your second refusal in 10 years, it's a 90-day suspension.
Wow.
And the judge can't do anything about it. And if it's your third refusal in 10 years, it's a year. The judge can't do anything about it. Now, even if you go to court on your OVI and you're found not guilty, so let's suppose you didn't take the test, you go to court, the jury says you were not impaired. That license suspension remains.
Because you've implied your...
Yeah, you broke your agreement with the BMV. Yeah. So that's one of the consequences of not taking the test. That fits your situation. So if you are a person who has to drive for their job, I would use the word truck driver, but truck drivers have a whole different situation. If you have a commercial driver's license,
the CDL places
your
a lot
first
more.
on your first OVI you lose your CDL for a year.
Yeah.
There's no
You
driving.
lose your livelihood. Yeah.
Yes, and if it's your second lifetime, gone.
You're done.
You're done. You can never drive. You'll never get a CDL again.
Well, I think the best piece of information you just gave in this segment is the fact that in order to give you the breathalyzer, they are placing you under arrest, which means they're going to read you your rights.
They're going to read your rights.
At which point those four little words ought to come out of your mouth, right?
Correct.
I want my lawyer.
Once an officer says you have a right to remain silent, anything you say or do can be used against you in a court of law. You have a right to an attorney if you cannot afford and want to be appointed for you. They've just given you really good advice. Take it.
Take it.
Yeah.
Now, at that point, do you continue on with the breathalyzer?
Well,
or do you wait till your lawyer gets there? What do you do?
Well, that's one of the things that happens in OVI cases, ones that proceed to trial, which are refusals, is one of the arguments on behalf of the prosecutor's office is, well, if you weren't impaired, wouldn't you take the test? And that's what prosecutors tell juries all the time. And it's a pretty effective little argument.
Yeah, it is. Yeah.
The problem is that most people who encounter this have never been there before, and they don't know what to do.
Right.
And they're scared, and they don't trust the machine necessarily. And it's when you see this machine, it doesn't look real sophisticated, folks. It looks kind of like a 1950s. It looks like your control panel right here with like only one button instead of 40. Okay.
Right.
It's a very
knobs and switches.
The knobs, there's a little hose that comes out that you blow into, and then this little digital readout like an alarm clock goes. It puts out a number, and that's it. And the thing makes all these clunky noises. It feels like a vacuum feeling. It goes clunk, 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 clunk.
I'm picturing the Flintstones.
The Flintstones. That's that's what the old intoxicalizers look like,
wow.
and the BAC Data Master.
Yeah.
So they don't look real sophisticated.
They can't. They have to be simple to operate.
They're simple to operate. And when you show juries what these things look like, they all kind of, come on, this thing can't be accurate.
It's what the guts inside do.
Yeah. And so you ask me what to do. If you really don't know what to do, say, I would prefer to legal counsel to make that decision.
Yeah.
Now,
and you're not refusing at that point.
Well,
though,
no, you're it's considered a refusal.
Really,
if you don't take the test,
right then,
for whatever reason you don't take it,
even though you have the right to an attorney present, it's a form of it is a form of interrogation, right?
It's not a form of questioning because they're asking for a bodily fluid. Once again, it's all part of this. What you gave up when you signed up for the driver's license.
Man, what a catch-22!
Yeah, it's a catch-22. Once you sign up for that driver's license, you have agreed to provide this, and so it's not technically an interrogation. It's part of that contract you entered into with the state. And so, it's difficult. The best from a defense attorney's perspective, when I see cases where people gave a reason why. Well, my buddy's a cop and he told me never to take the test. I asked a defense lawyer once and he said never take the test. Or I would like to discuss this with a lawyer. The cop says, well, do you know one you can call? And people say no. He says, well, that's on you, not on me. Are you taking my test
one
or
will
not?
Be appointed, and you just said you were going to appoint one.
You go down that road, they just mark you as refusal and go on. But at least at that situation, you have provided some explanation for why you didn't, because it is scary. I mean, you've been arrested. Most of the troopers are polite, they're friendly, they're professional.
They're going to be professional, absolutely.
They are professional, but they have a job to do, and their job to do is to collect as much evidence as they can to see if you're impaired, and if so, to convict you. And that's their job. Now, what happens is after your first offense, if you're convicted of an OVI, and you get pulled over again and you refuse a second time, or you refuse the first time on your second offense, that then becomes a separate criminal charge.
Oh, wow.
Yeah. So not only do they charge you with the OVI, you also get charged with refusing, because now you can't say, well, I didn't know about this implied consent stuff. And there's separate penalties.
Yeah, okay.
So you can go to jail. You can be pulled over. It could be your second offense in 10 years.
I was going to say, is there a statute of limitations on that?
20.
20, okay.
Yeah. So let's suppose you had a DUI 15 years ago. You get pulled over. The first time you took the test and blew over, so the second time you decide, well, I'm not going to do that again. I'm going to opt to refuse. What happens in that situation is then you would get charged as a first and 10, because that's the look-back period for an OVI, but you would get charged with refusing because it's your refusal within 20 years of being convicted of a prior OVI.
Gotcha. Okay.
So even if you beat the, I take that back. If you are found not guilty of being under the influence, then you beat the refusal charge, is what I meant to say. But yeah, there's a separate charge for not taking the test.
Wow.
So there are some consequences for not taking the test that can exist, particularly if it's a second OVI.
Right.
But by and large, the reason defense attorneys as a whole say take the test is because don't take the test is because most people fail. And because if you blow under, you're still going to get charged with OVI, because sometimes they will proceed. I had a trial. Person blew a 0.7.
Still close, yeah.
They thought he was impaired. We went to trial, and luckily, well, not luckily, but he was found not guilty.
So let's look at how they determined that he was under the influence.
It's field sobriety test.
So there's a standardized
there's three
test,
standardized tests that
Okay.
are used. The first one is called the horizontal gaze nystagmus test.
Right?
Yeah, most people call it the eye test.
Okay.
And basically, and most people don't understand this, but what it is, the officer moves his finger left to right in front of
And
your
you're
eyes.
supposed to follow it, right?
You're supposed
Without
to follow.
moving your head.
What they're looking for is an involuntary jerking of the eye. What happens is alcohol weakens all muscles in the body, including the muscles that control the eyes.
Okay.
So if you think of holding out a heavy weight in your hand, eventually your arm's going to start to shake as it gets tired, correct? The same thing happens to the eye muscles. If you move them back and forth, they get tired, particularly if you have to hold them in a position looking all the way to the corner of your eye. That muscle will get tired and it will start to shake. This is because of the alcohol has weakened the eye muscles, and that's what they're looking for. The second test is to stand, and you have to raise 1 foot 6 inches, 6 to 8 inches off the ground and count to 30 by 1,000s, and not put your foot down. So you have to stand on one leg for 30 seconds.
Okay.
That's basically the test. Yeah. That's probably, in my opinion, the most telling of all the tests. And then there's the famous walk the line.
Right.
But these physical tests that you do are what are called divided attention tests, which means that what they're actually doing is the way they're set up is that they want to give you a set of instructions you have to follow that uses your mind, and then they want to see what condition your physical coordination and body is in.
Yep.
So it's both the instructions and the mind. I'm actually certified by NHTSA to administer the field sobriety test.
Oh, wow.
Yeah,
okay.
I have the same training that the troopers have. And so I went and took the course and learned how to do all these tests and learned how what the theory behind all of them are. But that's essentially what they are.
There's some good theory behind those, though. That again, tough to argue with the trooper in court on those.
Yes and no.
Okay.
In my opinion, people can vary. I always use the example with my clients in the Olympics. You have 7 judges. The scores are not always the same.
Low and a high.
And every
right.
once in a while, you get that crazy Russian judge who lowballed somebody.
Which most of the time they throw the extremes out and use the middles.
Right. And so, thankfully, because of video, which is so popular,
I
it
know.
provides me an opportunity to provide my own score, if you will.
Right. By the way, those cop cams, they've been advertised. I want to get one of those because those look very interesting.
Yep.
Hey, we're out of time. I want to leave you with one thought. When in doubt, I want my lawyer.
Yep.
Thank you, Andrew. Andrew Stevenson, attorney at law, criminal defense attorney, and you can find out more information on his practice and what he does, and if you need his help, at StevensonCriminalDefense.com, and we'll see you next year.